Thanks very much, Keith. And apologies, everyone, that it's obviously what I'm talking about is fairly depressing. So you've not only got to think about running your business, I'm going to be telling you about what happens if you can't run your business. So sorry about the fact that it's depressing, but I'll try and show you some tips and things that you can think about, a bit like James was just saying, so that you plan ahead. That's the most important thing. So quick canter through what happens to your business firstly if you die. Obviously, it will depend on how your business is held, if you're a sole trader or if you're operating as a partnership or a company. Now, if you're in a partnership or a company, you might think, well, that's all right, there are others around who can run the business. But do they have your skills? Do they have access to the bank account? Are they able to step into your shoes? And obviously, with a sole trader, that's even more important. Is there another member of your team? Is there an employee who could step up, keep managing the bills being sent out, payments being chased, bills being paid, employees being paid, because nothing will stop people's goodwill than not being paid for doing their job. So where this is obviously leading is thinking about, well, does the business have to be sold? If you go, is there anyone to carry on the business, or is kind of your death the end of the business? Is there anything to sell? So you need to be thinking about those sorts of issues. Clearly, if you're thinking about, are the family going to come and join the business? Either that's your spouse, partner, or your children, obviously, or even further down the generations. Then if they're already in the business, you might say, well, all right, I've got people, I've got my succession sorted. But if they're not involved in the business and you're going to want to leave your business interest to them, is that a good idea? And I always say to people, well, would you want your business partner or obviously co-shareholder, would you want their spouse sitting at the table with you? Would you want their children making decisions with you about how you run the business? Are your children or even or your spouse going to have the same ideas as you? Would your children just want to strip out what they could get and go and spend the cash down the pub, or obviously on their education? Clearly, they're not going to the pub. So you need to think about, is it right that your family join the business? And obviously this will be picked up by James more, but when I'm talking to clients, I want them to think about, well, are the rights already there for what happens when you die? This might be in the shareholders agreement, it could be in the mem and arts, or in the partnership agreement. So have you got freedom to leave your business interests to whoever you want? And that's something that I always pick up with clients, because it's no good if I plan with a client to say that the business is going to go to spouse, if actually there are preemption rights, so the business can't go to the spouse. So slightly following on from that then obviously is saying, right, we'll think about having a will. And the backup for not having a will is you'll have the intestacy rules. I have not come across a client yet who, when I explain the intestacy rules, says, oh, well, that's all right, that's what I want. They're a bit of a flow chart about if you have a spouse, if you have children, parents, but the ultimate thing is if you've got no family, you can end up with Prince Charles getting your money. So if nothing else will drive you straight to my door or your own solicitor's door to get a will, it's knowing that he'd get your money. So I would say intestacy rules, nightmare, think about having a will. And following that is also thinking about, if you're divorcing but not divorced, get a new will. So if you have a will already, a decree absolute will treat the spouse as having died before you. So the now ex-spouse is taken out of your will or out of the intestacy rules. But if you're in the situation, and I have had this for a client who sadly died, and I'm dealing with the probate, they died during the divorce process, and the to-be ex-spouse got everything under their will. Now, that wouldn't be what they would have wanted. They were divorcing. So you must think about either doing a will to start with, or certainly reviewing and changing your will if you're in the process of getting divorced. So I say have a will. Clearly, you need to think very carefully about who the executors or trustees are, because the executors will be the people administering your estate. So they will have interim powers to deal with your shares, your partnership interest, or if it's sole trader, obviously, your business. Think obviously about who you want to receive your business interest. We talked about, is it right that your spouse comes into the business? Is it right your children come into the business? Clearly, there's some tax planning here, which is thinking about getting the value to your family whilst the shares pass back to or shares or the business interest pass back to the business owners with you. So there is some planning that you can think about there, which obviously time is short today. So I'm happy to take more questions either in the session or contact me afterwards. But I mention inheritance tax because you need to have a discussion and a look with your accountant primarily to do with whether your shares or your business interest generally would attract relief from inheritance tax under the business relief rules. There are lots of conditions, but essentially if it's an unlisted company or it's a trading business, then as long as other conditions are satisfied, you should get the business relief. And this can have a huge impact. I was talking to a client the other day, business interest of 2 million. Well, that's not in the inheritance tax net because it gets business relief. Clearly, when he sells his business interest and just has the cash sitting in his bank account, I'm sure he's intending to spend it, then that changes it. So the planning that he's undertaken in his will need reviewing. So again, think about inheritance tax. And I mentioned rights. This is obviously going to be picked up by James, and I've mentioned it already. Does someone else have the right to buy those shares? But it should be an option, not an absolute obligation. Otherwise, you'll lose the business relief. So that's something else to think about. So if you think dying is bad, I have to say that losing either mental or physical capacity is absolutely a nightmare and worse than anything practically. Clearly here, it will depend on if there's someone else in the business who can already step in, but can they really step in? So if it's a sole trader, is the one of your staff who has access to the bank account? Can you keep those payments going out and coming in? Are they able to carry on and replicate your expertise? Can they design the building? Are they the engineer with the knowledge that you have? So you need to think about all that. And as well, you need to think about that if it's a business partnership or a company. So that needs to be considered. I've mentioned about authorised to run the bills and run the business and pay the bills. But obviously then thinking about sole traders or partnership or limited companies. And if you don't have anybody appointed as your attorney, which is what I'll come to next, then the only option is for somebody to be appointed as a deputy, which is not probably what you'd want either. I would say that as part of your emergency planning, thinking about, well, what happens if I divorce? But also all of you running the business, think about what if you die, think if you lose capacity. Certainly, I advise people all the time on having a lasting power of attorney. So the attorney's role is essentially a very powerful one because they're going to step in and they're going to carry on running your business. So there's only certain things that they can do. So there are parameters around what they can do, and that varies depending on sole trader, partnership, or a company. But you always need to think about, do they have knowledge of the business? Is it realistic that they can run your business for you? Clearly, are they reliable? Are they trustworthy? Would you want them running your business? It's no good just having your mate because he's a good laugh at the end of the day. You need someone who at least understands your skills and can at least engage someone else to deliver that advice or run your business if you're not able to do it. Do you need to pay the attorney? If they're an employee, you might say, well, I'm paying them anyway, but aren't they carrying out extra jobs, extra roles? So you need to think about that. The main thing you obviously need to think about is how the business can continue to operate if you're physically or mentally incapable of operating it. And if it's shares that you own in the business, then the attorney can exercise your voting rights. So clearly your choice of attorney is very important, and you need to make sure that they've got the same aims, because certain decisions have to be taken by the shareholders and passed by the shareholders. So it's not just the directors who can go around doing whatever they like. So that's why I say that having an attorney is a very powerful position for them, but you also need to think about, do you want separate powers of attorney for your personal finances or for your business? Is it right that your spouse is trying to run your bank account, your personal account, whilst no doubt looking after you and also trying to run your business? But do you want your business partner involved in running your personal finances? So that's a very quick canter through things you need to think about.